it would be regulated. We have Code of Civil Procedure, so the case has to be strictly proceed on the basis of procedure that is prescribed therein. Likewise, which evidence to be led, which is relevant, which is not relevant, and in the manner, we have the Evidence Act. So this, which has to be strictly followed. Now, in contrast, when the parties go for arbitration, they are not, they don't want court system. They want that the dispute should be decided in a private forum, which is chosen by them. Of course, as I say, and that is the principle behind mediation also, the dispute is between the two parties, and particularly commercial dispute, but it can be any dispute. And it is, therefore, if the parties want resolution of dispute in a particular way, that freedom has to be given to them, should be given to them. So therefore, in this process, the arbitration, which has been there for centuries, become a very, very important method or alternative method of resolving the disputes. And therefore, the law recognizes, the society recognizes, the system recognizes that it is not necessary for the parties to approach the court only if they want, because they are the litigants. If they want their disputes to be resolved in a particular manner and outside the court system, they are free to do so. And here the question of party autonomy comes, and that freedom which is to be given to them in what way they want to decide the case. And this is what I would say is the philosophical or jurisprudential basis of party autonomy. So here, interestingly, and that is what our Arbitration and Conciliation Act also recognizes in so many provisions which are contained therein, that what kind of freedom which is given to the parties. Number one and foremost is freedom to choose the persons whom they want to settle their disputes. So therefore, parties are given the right to nominate their own arbitrators. Of course, the particular system would be there, but before that, in what manner it should go, that is in the arbitration agreement it is prescribed. So the two parties are deciding in the arbitration agreement how it is to be decided. Then it's not only that, what kind of procedure, as I said, CPC doesn't apply, that is under our Arbitration Act, it is very clearly stated, nor the evidence rules under the Evidence Act apply. And therefore the parties are free to devise their own procedure. And they can discuss that, and on that basis, and normally what happens when even the arbitral tribunal is constituted, and if something is not there in the arbitration agreement, first choice is given to the parties that what is the procedure you want to settle, and based on the consent of the parties, the tribunal settles that procedure. Only if at some stage parties are not able to agree on them, then only the tribunal comes into the picture and says that, okay, it should be in this manner or in that manner. Of course, at the same time, keeping in mind the due process and the equality which is to be given to both the parties. And what is interesting is that over a period of time, and that the speakers would speak in detail, it's not only the parties choose the procedure, and how the arbitration would be governed, and which law would govern, that is curial as well as substantive law, that also is their choice. And the way law has developed, and particularly, and it was stated by both the speakers yesterday as well, that even the two parties today are free, that is the Indian law laid down by the Supreme Court, to choose not only the substantive, even when both are Indian parties, choose not only substantive law of another jurisdiction, and they can say that, okay, we will, two parties, Indian parties, that will go to LCIA or will go to SIAC, and then that can be done. And it is just keep in mind the provisions of CPC section 20 and see the contrast jurisprudentially. Our section 20 of Code of Civil Procedure says, and while conferring which court has the jurisdiction, that where the cause of action arises or where the party defendant resides. Now, interestingly, the courts have held, and rightly so, that if a particular court lacks inherent jurisdiction, even the consent of the parties cannot confer jurisdiction. It's a complete departure when it comes to arbitration. That is what is to be seen. Complete departure, and the party autonomy goes to the extent of the two parties choosing a forum which under the court system or by applying the provisions of CPC, court may not have that, or that particular forum may not have the jurisdiction. So that is where it has gone to that extent. Having said so, then there are the topic which we are discussing, there are certain limitations as well to the party autonomy, particularly if in the arbitration agreement it is stated what kinds of disputes would be there. Naturally, the disputes more than that cannot be. There can be some accepted matters, some excluded matters. If the parties have initially decided, thereafter they cannot bring. Then if in the this institutional arbitration they have decided, then they cannot formulate their own procedure. It is the institution procedure which will be applicable. So there are some kinds of limitations of this nature which the parties, the speakers would discuss. And if I may here only say some of the judgments, or okay, when you people speak and thereafter I'll keep on giving my comments. So with that, I would request initially in the first instance, Mr. Pachnanda, that if you can spell out some of the limitations to the party autonomy.
Can you hear me? Thank you, sir. Thank you. Thanks, Justice Sikri. When I observe the developments in Indian arbitration law, with party autonomy being the focus of my observation, I see that over the last few years, there are two competing trends emerging, both from the manner in which legislative intervention has taken place in arbitration law, and also in the manner in which courts have interpreted or applied arbitration law in India. The first trend, and in fact that is the more promising trend, is that there is greater recognition of party autonomy in the arbitration regime. Even in the last few years, some of the judgments that the Supreme Court has delivered and some of the decisions that have come from Delhi High Court, there is an attempt to stretch the envelope and make our conventional notions of how law should be defer to party autonomy in matters relating to arbitration law. For example, in the PSL Wind Solutions judgment recently, the Supreme Court recognized that even in matters of domestic arbitration, parties can have a foreign-seated arbitration. And then the Delhi High Court in Dholi Spintex held that the choice of foreign law governing arbitration agreement is purely within the domain of the parties, recognizing that parties have complete autonomy to make decisions in these matters. In matters of recognizing orders of emergency arbitrators where there was some gray area, I see that the Supreme Court used innovative techniques to bring an order passed by an emergency arbitrator in the absence of any similar regime under Indian law, an order passed by an emergency arbitrator in an India-seated arbitration to be, and held that such an order would be relatable to an interim order passed by an arbitral tribunal seated in India, although emergency arbitration and emergency orders awards per se by an emergency arbitrator find no mention in Indian arbitration jurisprudence, or did not find any mention in Indian arbitration jurisprudence until then. Even in matters relating to arbitrability, a few years ago, there was some divergence of opinion that matters relating to landlord-tenant disputes perhaps may not be arbitrable, or matters relating to fraud perhaps in complicated questions may not be arbitrable. And in Vidya Durolia recently, a 3-judge bench of the Supreme Court restricted the scope of intervention in such matters, deferring and in fact upholding party autonomy in decision-making with respect to arbitrability of disputes. But there is also a parallel trend, as I mentioned in the beginning, where there is a sense of, where some of us get a sense that both the legislature and the policymakers and courts feel that there is requirement of some degree of intervention for the purpose of course correction, and to some degree, party autonomy is capable of being tempered, both by legislation and by decision-making by the judiciary. A classic example is the legislation in 2015 that brought in time limits, which required that arbitrators have to render an award within 12 months, and parties can only extend this period up to a maximum of 6 months, but parties have no freedom to extend the period for the purpose of completing an arbitration beyond 6 months, plus 12 months, which is 18 months. And it is necessary for parties to go to a court for the purpose of extension of time, and at which stage the court will have jurisdiction to even observe whether there is requirement for greater intervention, sometimes even replace one or more arbitrators or impose certain other conditions on the manner in which arbitration is being conducted. That is clearly, in my view, a policy attempt to restrict party autonomy to some extent, but we will discuss later there might be good reasons for doing that in the Indian context. The other aspect, of course, is a very interesting development with the introduction of Section 12(5) of the Arbitration Act, coupled with the 7th schedule, which imposes certain criteria that would disqualify an arbitrator from continuing until after the dispute has arisen. Parties again enter into an agreement in writing, affirming that despite such disqualification, an arbitrator can continue as for example, I'll give an example, that an employee of one of the parties, or a former employee or a former consultant of one of the parties, ordinarily until 2015, there would not have been that big a concern, but post-introduction of the 7th schedule, that would invite a disqualification until and unless parties again enter into a contract to sort of agree again that it is okay to continue with the appointment, with an arbitrator that is an arbitrator who is disqualified under the 7th schedule. To that extent, perhaps the intervention made by Section 12(5) by the legislature is consistent with the general trend internationally to sort of highlight disqualification criteria with respect to arbitrators. But this principle was extended by one step in the Supreme Court's decision in TRF Limited, where not only was an employee held to be ineligible for appointment as an arbitrator, but the employee of a party was also held to be ineligible for the purpose of appointing a sole arbitrator in a unilateral arbitration mechanism. It is quite common practice in India, as a lot of you know, that in public sector undertakings, and often in some private contracts between private parties, there is scope for unilateral. Parties agree to a unilateral appointment by one of the parties of an arbitrator. And that is an area that became a subject matter of intervention in TRF Limited by the Supreme Court. And in Perkins, this principle was extended further, where it was as a matter of general principle declared that unilateral appointments of sole arbitrators, although not relatable to any statutory provision, but would be improper and would invite a disability by expanding the scope of section 12.5 in a certain manner. The attempt, of course, I think has good reasons, and we can discuss that a bit later, but I think that that is also an effort that restricts party autonomy in the sense that two parties have voluntarily chosen that there could be unilateral appointment, but the Supreme Court decision now says that is improper. But as I said, there are good reasons in the Indian context for some of these decisions. So, I mean, this decision also invites an ancillary concern as to what happens if parties have, prior to this decision, already started an arbitration, or the arbitration has already culminated in an award, and the parties have not raised any objection with respect to unilateral appointment of one arbitrator. And that is a subject matter of new jurisprudence now, because as I recollect, there are conflicting decisions in various high courts. Some high courts are taking a view that if the parties have proceeded to arbitration without any objection, then principles of party autonomy require that we respect that award. And the other high courts have taken a view that in view of the Supreme Court decision, this disqualification goes to the root of jurisdiction of the tribunal. And irrespective of whether any objection was raised or not, an award of that nature can be challenged and can even be set aside. So broadly, I think these are two competing trends that are emerging. Before I conclude, I want to make 2 points. When I observe these trends, I think that there is generally a greater intervention to reassess requirements of party autonomy by the legislature than there is by courts. There is a general trend that, barring some exceptions, courts generally are in favor of upholding party autonomy. And the other trend, of course, is that when it comes to domestic arbitrations, there is greater intervention both by legislature and by courts. But when it comes to international arbitrations, there is a much greater tendency to uphold the decision made by the parties and to respect party autonomy. Thank you, sir.
Thank you, Mr. Gaurav Pachnanda, for this remarkable exposition, where on the one hand, you say that by judicial pronouncements, the Supreme Court has expanded the scope of party autonomy by allowing them even to choose foreign seat, even when both the parties are Indian parties, and allowing them to have the substantive law also and procedural law also seat as well. And on the other hand, Section 12.5, which has been introduced and which has restricted the party autonomy to some extent, and along with the Schedule 7, and these are two contrasting, but what is the public interest, or what is the rationale behind two contrasting line of thinking? We will come to that, and I'll ask you a question on that. But before that, I will like to advert to now Renu, that look, some of the limitations which have been mentioned by Mr. Gaurav, but do you think that there are many other limitations also? Can parties agree on any matters they like, or whether a tribunal is bound to follow what the parties agree in all circumstances? And what is the public policy behind such provisions? If you can highlight that.
Good morning, everyone. Check. Good morning, everyone. Good morning, everyone. Okay. Good morning. Thank you for being here with us today morning. I have 12 minutes, just the Sikri has allotted us time. So it's a topic which can take a long time, but I am going to restrict my presentation today to some conceptual points without going deeper into judgments and case laws. I'll deal with some examples, but I would try and focus on some concepts as to what is the purpose of these limits and what are we trying to achieve through these limits. With that, I think I want to start with saying that even though arbitration and courts are looked as two separate forums, they are not mutually exclusive. Justice Chandrachud said yesterday that we have to look at courts as supporting arbitration. And why I say this is important is the entire concept of party autonomy and the limitations to party autonomy which we're looking at need to be seen from a certain lens, not necessarily as a restriction that we are trying to restrict parties from doing something, but that this is something which helps in dispensation of justice. Both courts and arbitral tribunals, the exercise, even in tribunals as a private forum, is dispensation of justice. And I think that is very important to not lose sight of in a situation where the parties want to tilt the balance towards party autonomy and the factors are being looked at to see whether it skews it against judicial dispensation of justice. That conflict in resolution is often looked at to move towards dispensation of justice. So I would invite the audience and also my panelists to look at these limits from a few lenses. Not see limitations as anarchy, as, you know, which is another phrase which Justice Chandrachud used yesterday, that a party autonomy does not mean party anarchy. So do not look at limitations as anarchy. In fact, look at them as some solutions to not introducing anarchy. Look at them as supporting judicial justice dispensation. Look at them as sustaining an arbitration, and most importantly, look at them so as to not imperil enforcement of the award. Because the end goal for an arbitration, the outcome, you know, we need to see it not just in terms of an arbitration proceeding, but what comes from it at the stage of a challenge, which could be at the seat, and then enforcement, which could be at many other places. So where, and I will come to examples on that. So that is the context I would like to set for my talk. A small sort of anecdotal story also that I'd like to keep everyone to keep in mind while looking at autonomy is the story of Icarus, the Greek mythological legend that his father said, you know, you can fly as high as you want, but there is a condition, don't go too close to the sun. The fact that he did, and the fact that going too close to the sun led to his death is an abuse of power. He had a power which was abused, and rightly so, his father imposed a certain parameter in which he should have exercised that power, and we would have perhaps heard more stories about Icarus. Moving on, I would like to divide my presentation in three parts. One is to look at autonomy and the limitations to it in the procedure, the arbitral procedure, and two, look at it in the context of two overarching principles which control the autonomy, which is public policy, as Justice Sikri has asked me to talk about, and procedural due process. These are two factors which broadly are available to look at every restriction, because these are the two pointers which courts are always looking at to test whether the autonomous conduct of the parties should be sustained or should not be sustained. In the arbitral procedure, and I will very briefly touch upon these points given the time restriction, we can look at it in terms of stages. So you have a stage before commencement of arbitration when you're still looking at an arbitration clause draft. When you're drafting an agreement, you have a choice of full autonomy at that stage, and the restrictions that we talk about should be mindful of even at that stage. You can choose whether you want an ad hoc or an institutional arbitration. You can choose your number of arbitrators, qualifications, procedural matters. That autonomy is still there to some extent even after you've signed the agreement, but the proceedings have not yet commenced. But the next important stage, which comes in after the establishment of tribunal, brings in heavier limitations as we see. Some very important limitations to autonomy which exist and are tested across jurisdictions are that the agreement must be valid according to the law governing it. Number two is the arbitrability. Mr. Pachnanda spoke about that in detail. So if you're having an agreement and the subject matter of that, whether it is capable of arbitration or not, is a limitation to be seen at that stage. And the third is mandatory rules of the lex arbitrary. So these are two very crucial limitations to not be lost sight of. The next point now that I will come to is the limitations of procedural due process and public policy. As I said, these are the two, these are slightly fluid concepts, if I may use that word, because the contours of these cannot really be defined and boxed, and these are principles which are still developing. Public policy as a concept is still developing with judicial precedents. These two principles, if I have to break them down, the due process part of it, so due process and procedural, procedural due process, if I have to break it down, would be looked at in two ways. One is equal treatment of parties, and the other would be arbitrators' independence and impartiality. Now this equal treatment, and I'll give some examples, the party autonomy exists and there is equal treatment which comes both from New York Convention, model law of the UN in arbitration. But there are some institutional rules which are trying to play around with this. For example, there is a new 2021 ICC rule which gives authority to the ICC court to disregard in exceptional circumstances an agreement by parties on method of constitution of an arbitral tribunal. The ICC court may appoint each member of the tribunal if it is necessary to avoid a significant risk of unequal treatment and unfairness that may affect the validity of the award. We are finding these as sort of a codified contour to party autonomy in institutional rules. The second safeguard to party autonomy, which is independence and impartiality of arbitrators. In the Indian context, the schedule takes care of it and gives you situations where the tribunals should be mindful and the lawyers should be mindful of situations where there can be a conflict of interest and situations where the independence and impartiality of arbitrators should not be compromised. I would also like to very briefly talk about public policy as a limit to party autonomy in choosing substantive law. We heard about the Indian law position in PASL, which is a Supreme Court decision, and the court has said two parties are free to choose the substantive law. I'd like to give two international context examples. One is a case called the Soleimani versus Soleimani. There the object of the contract was export of Persian carpets out of Iran, and that was in breach of the Iranian revenue laws and export controls. So the court of chief rabbi applied the Jewish law and said that the illegal purpose of the contract had no effect on the right of parties under the applicable law. But the courts in UK held that the illegal object of the contract was deemed as falling under English public policy. There's another example of a Swiss case which is called Westcare Investment versus Jugo Import, and there the contract was governed by Swiss law. The seat of arbitration was Switzerland. Some obligations under the contract involved paying bribe to some certain Kuwaiti officials. The Swiss federal court in this case rejected the challenge to the award on the basis of illegal purpose of the contract, But the award was also challenged before the English court as opposed to public policy, but the English courts enforced the award. They balanced the public policy here, which was of discouraging corruption, with the public policy of sustaining international arbitration awards. I'd like to talk about another limit, and this would fall in a category of public interest. Public interest also overlaps with public policy. So this is a very interesting case. Let's say you've got institutional rules which contain certain nationality restrictions on appointment of arbitrators. Would those rules be considered as valid or conflicting with party autonomy? There is a case, Jeevaraj versus Harshwani. That's an interesting case on this issue. The agreement said 3 arbitrators, and that all 3 arbitrators should be a respected member of the Smiley community. Jeevaraj had challenged the appointment of the arbitrator because they questioned it, and it was sort of allowed to be that. Sikri, do I have some more time? 2 minutes? Okay, I will just take 2 more minutes. There is one more aspect on institutional arbitral institutions. Very quickly, I will speak about the emergency arbitration rules of several institutions which provide a way to override party autonomy. So you can have parties agreeing to a 3-member tribunal, but several institutions like the ICC and SIAC provide that in case of an expedited hearing request, they have the power to appoint a sole arbitrator. There are institutions which respect the party autonomy in that case. For instance, Hong Kong, the China International Economic Trade Arbitration, the Swiss Chambers, yes, those are the institutions. One last point that I will make for my arbitration is one case from Singapore High Court, AQZ versus ARA. In this case, the SIAC rule, which said that in an expedited hearing, we can do 1 arbitrator instead of 3, which the parties have agreed to. That rule was challenged as being violative of party autonomy, and the application to set aside was filed. The Singapore court in this case held that we are going to enforce the rule for the reason that the dispute is small, the quantum is not much, and the facts of the case warrant an expedited procedure, and therefore we will allow it to override party autonomy. With that, I am mindful of the time. Thank you.
Thank you, Renu, and it was really a treat hearing both of you. On the one hand, how judiciary in certain areas have expanded the party autonomy. On the other hand, as you rightly pointed out, public policy or public interest, how they weigh and control some of the aspects of party autonomy, and maybe Section 12(5) is also based on that of our Indian Arbitration Act. And what is the rationale behind the 2 contrasting development and how they coexist? These have emerged, and what is the connect of that with the party autonomy? I'll request Mr. Stephen to throw some light on that.
Yes, well, as they used to say on Monty Python, now for something completely different. I feel a bit like a sore thumb at this arbitration conference. I'm speaking at an arbitration conference devoted to arbitration, and yet my topic is the emergence of commercial courts. And despite Justice Sikri's brave attempt to get me to explain how it is related to the limits on party autonomy, I confess I've failed completely, so completely that I'm prepared to offer a bottle of champagne to somebody who can come up with a link between limits on party autonomy and arbitration and the emergence of commercial courts. I don't think there's any connection whatsoever. But I think that the reasons for the development of international commercial courts over the past few years and the implications that has for arbitration is sufficiently important to spend a few moments talking about how they emerged, why they emerged, and whether they can fill gaps or not. Now, until the early part of this century, the fact of the matter was there was really only one commercial court worthy of being called a commercial court in the sense of attracting litigation from around the world to be decided before that court. And it was a commercial court in London. But ironically, the origins of the commercial court in London have nothing to do at all with wanting to resolve international disputes on a large scale. It has its origins in a resolution of the Judicial Council in 1892 that there should be a commercial court capable of resolving disputes from the City of London, because of a feeling that the judges of the Queen's Bench were so awful at resolving commercial disputes, something had to be done. And famously, the last straw was a decision of a judge, Mr. Justice Lawrence, who was described by Lord Justice Mackinnon as a very stupid man, very ill-equipped to be a lawyer, an even worse judge. Now, that's quite an accolade. He famously decided a general average case about which he knew nothing whatsoever over a 22-day trial, reserved his judgment for 6 months, and came out with a judgment that bore no relation at all to what had been argued, and was overturned in the Court of Appeal both on fact and law. Funnily enough, it was the same feeling about London not having a mechanism for deciding commercial disputes with commercially minded people that produced in the same year, 1892, the London Chamber of Commerce, that now is the London Court of International Arbitration. But it was from those very parochial origins from 1895 that the London Commercial Court became, and still is, a recognised international commercial court deciding disputes with people having no connection at all with the country, purely because of the quality of the judiciary and also, to some extent, the English common law, which is respected around the world for being certain and reliable. But what's happened is, in and after 2006, we've seen a proliferation of a number of different commercial courts around the world, which I think could be divided into a number of different groups. The first starts with the establishment in 2006 of the Court of the Dubai International Financial Centre, DIFC, and that was followed quite rapidly by the Qatar International Court and Dispute Resolution Centre in 2010, the Abu Dhabi Global Market Court in 2015, and most recently the Kazakhstan's Astana International Financial Centre Court in 2017. And what all those courts have in common is that they are courts that sit in a jurisdiction where the domestic courts apply Islamic law, and where, for example, that causes potential problems for investors, particularly given the restriction on enforceability of contractual interest. And so, in order to attract investment to those jurisdictions, what was very cleverly done was to set up a totally parallel judicial system into which parties could contract, which applied completely separately from the domestic Islamic law, typically English common law, and with a number of judges from different jurisdictions, many of them from England, and Michael Huang, senior counsel from Singapore, who was an ex-chief justice of the DIFC court, famously described it as a common law island in a civil law ocean. Secondly, and distinct from those ICCs, I would place the Singapore International Commercial Court, which was set up in 2015, into a different category, because it's obviously much, much more ambitious. Plainly, that's not a court that sits in a jurisdiction where the domestic law applies domestic courts apply Islamic law. Quite the contrary. I mean, we all know that Singapore is a very, very distinguished common law system with a reputation of the highest nature. What the Singapore International Commercial Court was about was doing something more ambitious, which was making Singapore a real hub for international dispute resolution, complementing the already successful Singapore International Arbitration Centre. And also, as Chief Justice Menon said at one of the openings of the legal year, it was also about laying the groundwork, quote, for a freestanding body of supporting commercial law. And what that was a nod to was a complaint that one of our Chief Justices, Lord Thomas, made in a 2016 Bailey lecture about the problem with arbitration, which is because of the confidentiality of arbitrations, the prevalence of arbitration was hampering the ability of the common law to develop the response to new commercial law problems. And the Singapore Commercial Court has a much more varied makeup than domestic courts. So, for example, it's got 19 international judges, not just from the common law world. Justice Sikri sits on the Singapore International Commercial Court as an international judge. But as well as having common lawyers, it's got judges from civil jurisdictions like France, Japan, and China. So that's the Singapore International Commercial Court. I'm sure you've heard of all the courts I've been talking about up until now, but I'm now going to come on very briefly to some commercial courts I suspect none of you have heard of at all, and they are a group which would include the Chamber for International Disputes of the Frankfurt Regional Court, set up in 2018, the International and European Commercial Court of the Paris Court in 2018, the Netherlands Commercial Court of 2019, the Stuttgart Commercial Court in 2020, the Mannheim Commercial Court in 2020, and also, though it ultimately failed because of judicial hostility, the Brussels International Business Centre. Now, you won't have heard of all these these commercial courts because they really aren't, in any real sense, international commercial courts. They are all, in fact, a response to Brexit. What happened is, after Brexit, there was a feeling amongst some of our European colleagues that the commercial court would face problems in attracting litigation there for the future, and therefore they wanted to set up rival European commercial courts with a view to poaching some of London's business. It's still too early to say whether or not that's going to be successful. My view is it is very unlikely to poach much business, if at all, from London. And in truth, if you look at what some of these European commercial courts are about, very often they're doing nothing more than permitting people to make submissions in English. Well, I don't think that's going to get them very far at all, quite frankly. And nor is there any real prospect of having an international bench of judges in the way in which, for example, they do on the Singapore International Commercial Court or in the Middle Eastern courts I've been talking about. In the case, for example, of the German courts, the German constitution precludes the possibility of there being non-German judges. So that's why I say that these commercial courts I've been talking about have all been set up for a number of different political and geopolitical reasons, but the one thing you can't say is they were set up as a response to limitations on party autonomy in arbitration. But having said that, there are a number of respects in which I think these international commercial courts can fill the gap that is provided by limitations on party autonomy. So, for example, the restriction on arbitrations being able to decide matters that are non-arbitrable, plainly in principle, doesn't apply to a court, where the jurisdiction doesn't depend upon the same basis. Likewise, another very important benefit, gap-filling benefit, that an international commercial court can provide is the ability to allow joinder of parties in circumstances where you can't join them in an arbitration because there is no contract between the parties allowing them to be joined. The court doesn't suffer from the problem of having to depend upon a consensual jurisdiction in order for joinder to happen. And then there's one other point I just want to mention that courts fill a gap with in arbitration where arbitration is taking place in model law countries, and that's the ability to appeal. And the one thing I find very puzzling, and I'm interested in other people's views on this, one thing I find puzzling about the arbitration position in model law countries and the limitation on party autonomy is the ability to have a right to appeal. I've got no problem whatsoever in the parties saying we don't want to have a right to appeal if the tribunals screw up and make a real mess of the law, but I don't see what the fundamental philosophical justification is for saying parties to an arbitration inherently are not able to appeal on points of law. And interestingly, a report of the Law Reform Committee of the Singapore Academy of Law recommended quite recently that Singapore change the position and allow there to be an appeal on points of law subject to restrictions. But as far as I can see, but I'm interested in any further information from our colleagues who I can see over there from Singapore, it looks to me at the moment like that recommendation has been kicked into the long grass. So that, Justice Sikri, is all I wanted to say.
Thank you, Mr. Stephen. But of course, you have mentioned that I don't see any connect. I can, to some extent, say one a very brief remark. It is party autonomy, but not in arbitration. You are right to that extent. But rather, I would say it's a party autonomy giving them a chance to even go to another court. I had said in the context of Section 20 in my opening remarks of CPC that where a particular court lacks inherent jurisdiction, even the by consent of the parties, you cannot confer jurisdiction. So going to a different jurisdiction in arbitration, choosing substantive law of different jurisdiction, even when both the parties are Indian parties, that's a judgment of the court now. So that is the expansion of party autonomy. And in that context only, I would say that it is another expansion of party autonomy that they are permitted to even choose a foreign court. Yes, international court, international commercial court. Yeah, what are the reasons and why it is so? We would come to that little later. Coming back to the party autonomy and limits of party autonomy, Mr. Gaurav, I have 2 or 3 questions to each of the panelists, and thereafter I'll throw open, these questions which arise from their presentations. Mr. Gaurav, in the first instance, you tell me, you have mentioned those contrasting provisions and where on the one hand the party autonomy is expanded and on the other hand it is curtailed. There must be some rationale, some policy, some of the policy reasons and public policy or public interest aspects were explained by Renu. But can you tell us the 2 contrasting trajectories which have come, what would be the rationale in these contrasting approaches?
Yes, sir. Thanks a lot, sir. Taking it a bit forward from what Renu said, that broadly the concern is dispensation of justice, I actually think that there is something more happening in our country when it comes to arbitration law. And the pattern is gradually emerging. I think no law can be seen in isolation. The legal developments in India's arbitration law have to be seen in the context of the reality of our civil court system. And I think that there is a divergence of the jurisprudential basis of arbitration between international arbitration and domestic arbitration. I think the policymakers as well as the courts are very happy not to interfere in international arbitration and attempt to meet the international benchmark of minimum interference. But when it comes to domestic arbitration where disputes are being decided by between Indian parties, I think there is an awareness of not looking at domestic arbitration purely as a contractual dispute resolution mechanism between the parties, but also gradually looking at it as some kind of delegation of power by courts as well. In that sense, I get a feeling that there is a gradual development of jurisprudence that a domestic arbitration should have greater supervision by the court, because if the arbitration fails or results in a bad award, it will add to the workload of a system and defeat the very purpose of why we are promoting domestic arbitration. And also that domestic arbitration should be so efficacious that it should result in finality. At the same time, it should not result in an outcome that would be so fundamentally different from the outcome if the parties had decided had their disputes decided before a civil court. So if you see, for example, the introduction of Section 34A regarding patent illegality being an additional ground for setting aside domestic awards, or if we start looking at, for example, the power of contempt that is recognized in Section 27(5) of the Arbitration and Conciliation Act, I feel, sir, that when it comes to looking at domestic arbitration, it is, and I don't think this is improper, I think this is absolutely correct because of the requirement of the practical reality of our system here, which is clogged, which is overloaded. So I think courts increasingly look at arbitration when it comes to adjudication of disputes domestically as some kind of a semblance between a contractual dispute resolution mechanism coupled with some kind of delegation of power or authority by courts. And I think that is a trend that is emerging.
Thank you, Gaurav. And I'll add one, my comment to that. What I feel is that when we say that the parties have a choice to even choose different jurisdictions, different substantive law, etc. So in one sense, in this era of globalization, when there are cross-border disputes, international arbitrations are happening because of that reason. So it is expanding the contours of party autonomy in that sense. But when we come into the context, see it in the context of section 12.5, which you said, at that the policy or fundamental policy behind such a provision is the sense of justice and transparency, integrity of the arbitral system, that the arbitrator was not biased in any way. And therefore, the questions may arise that at that time, yes, there has to be disclosure, but interestingly, we have on the one hand, Schedule 5, and then we have Schedule 7. Schedule 5 doesn't make an arbitrator ineligible, but then he has to, if he has or she has some interest in the matter, there's some disclosure is to be given. On the other hand, Schedule 7 makes that person ineligible. Questions have arisen, and I'm adverting to you now in this context only, then continuing this discussion, that even when it was known a particular person may suffer ineligibility because of Schedule 7, and but it was known to the party, either there is a consent given by that party in writing or otherwise, which is say recorded by the tribunal in the proceedings, that this disclosure is made and the other side has no objection, but award is passed. After the award, that objection is taken. So on both the aspects, in the second aspect, whether it would amount to waiver, because the way Gaurav had mentioned some of the judgments of different high courts in different sense, how the jurisprudence is developing in post-award insofar as challenges to these awards on the basis of bias of the arbitrator or ineligibility of the arbitrator are there. And what is the law in other jurisdictions, if you can kindly throw light on that?
Thank you for that question, Justice Sikri. I think the position which is developing is very interesting at a post-award stage to see, and I'll use what Stephen said as a starting point. I mean, Stephen said that he sees no problem in parties saying, you know, no appeal to an award. So what we're really looking at is if the parties have agreed in their agreement that either no review or a limited review or an expanded review, are those agreements which are in the nature of autonomy of the parties, are they going to withstand scrutiny at a challenge stage, at an enforcement stage? I will split it into 3 stages. One is where the parties are excluding completely the judicial review. There are some countries which have found full favor agreements to be unenforceable, and those are Brazil, Egypt, Germany, UAE. India, there is a Shin satellite where there was an agreement where the parties tried to say, not tried, they did say that, you know, there will be no appeal or review of the award, and the courts said that that clause is not enforceable. They severed it, and then the arbitration was allowed to happen. There are some jurisdictions which give us some pointers on how to look at these restrictions. Swiss law, for instance, says that we will allow you to exclude it provided the parties have no link with the country of the seat of arbitration. So if the parties have a link with Switzerland, an advance waiver agreement will not be held to be enforceable under Swiss law. There are also certain, I think, Switzerland, I think, says some other parameters which are laid down to see whether you can exclude it. 2-3 circumstances where courts have held that these will not amount to a full waiver clause. For instance, just writing award shall be final and binding is not a waiver clause. Writing that you're excluding a right to appeal may not be, that may not be an enforceable clause. The consequence of that waiver is important. I mean, one might think that the consequence is that I cannot challenge the award at all, but it's going to come back to you at the stage of enforcement. That is never excluded. You might want to exclude the challenge, but the enforcement stage scrutiny of the award is something that will never get excluded. There are some countries which are allowing a limited exclusion. So instead of a full exclusion, and I think England is one of those, there are some grounds which are held to be non-mandatory. I think that's section 69, and parties can opt out of it, wherein section 67 and 68 say that there are certain mandatory grounds and we cannot allow you to exclude review of an award on those grounds. German law says pure public interest grounds not waivable, but if it is a general public law interest. So non-arbitrability and violation of public policy are seen as pure public interest grounds, and you cannot exclude them. I'll also very briefly talk about the policy considerations which are behind restricting this review of awards. One is protection of the interest of parties. I mean, what you are doing is ought to again look at, be compliant with a procedural due process, and therefore that protection of parties' interest, and there is protection of third parties and public interest, which also needs to be looked at. There's another position across jurisdictions on expanding judicial review. So perhaps saying that allowing a full review on merits of award, and there are some different opinions in France, New Zealand, etc. And I think we can talk about that at a later stage.
Thank you. So I now come back to my dear friend Stephen. You have, while explaining how the ICCs have come up in last few years in different jurisdictions, for a moment excluding those, which may not have true character of international commercial courts, as they are only applying their Islamic laws, etc. But coming to the example of English International Court or SICC, Singapore International Commercial Court, you mentioned in the process that some of the advantages, as I said, first of all, that look, it is in a way party autonomy, that they are not in arbitration, but yes, apart from arbitration, they are choosing some commercial court also, international commercial court also, and they want to go there. You mentioned some of the advantages, like the issues or the disputes which are non-arbitrable can be looked into by the courts, the issues of joining of the parties, and most importantly, if I may say so, it was right to appeal. Many times in the arbitration, it is felt that, look, because on merits you cannot challenge. It is only on some aspects of jurisdiction that you can challenge the award. And I have seen that parties many times are not happy with the outcome. Many times even both the parties are not happy with that outcome of the, as far as arbitral process is concerned. And therefore, they find that right to appeal is there. But at the same time, I have seen, and I can say so from my experience of sitting in Singapore International Commercial Courts, that while doing the, as a court, dealing with the matter, sometimes some of the aspects or some of the good practices of arbitration, they may be incorporated. Do you think here, can you throw light on this, that what are the good practices of arbitration which can be imbibed into the commercial courts, international commercial court, to make them more progressive?
Sure. Before I answer that question, I think in the light of your valiant attempt to find a link between the development of commercial courts and limits on party autonomy arbitration, I think you've earned yourself a bottle of champagne. Thank you. But on your question, I think the reference to the Singapore International Commercial Court is particularly apposite about the way in which you can incorporate arbitration practice into the process of the court itself. I mean, a number of points occur to me. On point one, despite my railing against assuming that you can't have a right to, or preventing you having a right to appeal against an arbitration award on errors of law, there is no doubt that for some parties, finality and having a quick resolution is very, very important. And what's interesting about the International Commercial Court is that parties can agree that the decision at first instance is binding, effectively contracting out of a right to appeal, subject only to the decision not being affected by fraud or illegality or infringing fundamental principles of natural justice. And that's quite an extraordinary thing for a court to do, to actually say, you've got no right to appeal from our decision if you agree that should be the position. The same is true of another provision affecting the international commercial. I mean, one thing I think that people in common law jurisdictions think is important about courts is open justice. Justice must be seen to be done. And yet we know that one of the great advantages of arbitration, as seen by the parties, is that they don't wash their dirty linen in public. They want things confidential. The innovative thing about the International Commercial Court in Singapore is, once again, the parties can agree that the hearing should be in private. So they become confidential, like arbitrations. Thirdly, on disclosure or discovery, effectively the way in which the International Commercial Court approaches document production is as per the IBA guidelines. It's request-led. And then finally, although I don't think you can say this mirrors the practice in arbitration, where you can actually select your judges, your arbitrators, you obviously can't select your judges in an international commercial court. I think the fact that you've got a pool of judges that are drawn from a far wider group of judges than simply domestic judges in, for example, Singapore, does mean that you can provide the parties with reassurance that they can have appointed to the case people who are more in tune with the underlying policy and the law of the jurisdictions from which the parties come. So I think international commercial courts, you can get the best of both worlds in some ways.
In the same line, another question I would like to ask you. There may be a challenge, and it is being discussed, about the enforceability of the judgments of the international commercial courts. So do you think here, I mean, from what you said earlier, expanding on that, some form of hybrid system of arbitration and ICC which can be helpful in this regard?
Yes, well, let me start by saying that I actually think that the extent to which arbitration practitioners laud the operation of the New York Convention and say that common law judgments are much more difficult to enforce, I think that although there is some justification for that, it is rather exaggerated. I mean, the proof of the pudding is in the eating. People litigate their disputes in the International Commercial Court and are not fussed about the enforceability. If they were, they would arbitrate instead. And the simple fact of the matter is that, you know, in Commonwealth jurisdictions, there is usually mutual enforceability by registration, even where you don't have that. In many common law jurisdictions, you can enforce the award at common law. It's true that that's more difficult in civil law jurisdictions, but we all know that even arbitration awards, despite the operation of the New York Convention, have difficulties being enforced in some civil law jurisdictions in Southeast Asia. But going back to your specific question, can arbitration provide some additional support for the enforceability of common law judgments? There is a rather interesting practice that was invented by the always ingenious Michael Huang when he was Chief Justice of the Dubai International Financial Center Court, where he dreamt up this way of effectively laundering a common law judgment into an arbitration award so you could then enforce it under the New York Convention. And the way in which it works is that, and it's based upon amended DIFC Court Practice Direction number 2 of 2015, effectively what it provides is that at the time of entering into an arbitration agreement, or entering into a jurisdiction agreement submitting a dispute to the DIFC court, the parties can also add an arbitration agreement referring any dispute over the payment of a DIFC monetary judgment to arbitration in DIFC, subject to certain criteria being met, like judgment's taken effect and it's not subject to appeal. And then if the judgment debtor refuses or doesn't pay the judgment debt, the judgment debtor, creditor can then refer what's called an enforcement dispute to arbitration in DIFC. And if it then gets an award in its favour, it then it can enforce the award under the New York Convention. It's a rather ingenious method of laundering a common law judgment into an arbitration award. So you get the benefits of a court judgment, but the benefits of the New York Convention when you seek to enforce the award. I don't know whether any experience of this ever having happened. I think in practice there must be some difficulties. I mean, if, for example, the party who doesn't pay says, well, I agree I'm liable to pay, but I simply haven't got the money, I can't pay at all, I'm not sure what difference there is that an award can then resolve so as to provide enforcement on the New York Convention. But subject to that, it does seem to me an interesting way in which you can marry the two together.
Thank you very much. I had some more questions, follow-up questions, but I'll stop here because about 13 to 14 minutes are left. I would like my audience to ask the questions to the panelists if they want, so I want to give them chance. Please, any questions which have come?
Thank you, Justice Sikri. Yes, I think we have a question from the audience. Is there a mic runner there, please? Siddhant? Yeah, right.
Good morning, I'm Siddhant Kumar and I'm a practitioner in the Delhi High Court. I wondered on the question of arbitrability as a limit to party autonomy. Is there some useful, on the one side, some attempt can be made on the UNCITRAL level to have some uniform rules of arbitrability to sort of enhance party autonomy? And this sort of comes from a recent Singapore High Court case where operation and mismanagement of minority shareholders of an Indian company was held to be an arbitrable issue in a Singapore-seated arbitration. But that would, in a sense, lead to, I foresee, a number of enforceability questions. That's on the one side. On the other side is the question of certain Indian laws being circumvented by international awards. These cases arose from Cruise City versus Unitech and NTT Docomo, where Indian law does not allow a foreign investor to have a guaranteed return on an equity share. But the International Arbitral Award granted the foreign investor that guaranteed share, guaranteed return as damages, which was subsequently enforced. Now, leaving aside the merits or demerits of whether such a restriction should exist, but that's a sovereign function, parliament exercise in public interest to have such a condition. The arbitration award system entirely circumvents that public policy goal. So on both sides, do you think there is some balance that needs to be brought in and some uniformity which enhances party autonomy on the one hand and creates a space for public policy interests on the other?
Siddhant, I agree with you that there is a, when you look at this entire problem from the Indian perspective sitting here, I think I agree with you that there is something to be said in favor of a uniform protocol on what is arbitrable and what isn't, so that enforceability related issues do not arise. In fact, my first reaction when I read about the Singapore judgment was the same, that will Indian courts eventually enforce an arbitral award relating to an operation mismanagement action, which ordinarily they would not have if it was a domestic award. In fact, the arbitration would not have proceeded. As I said, I think that when you look at arbitration, I mean, you can't just look at it from Indian perspective. There is an international perspective to arbitration. So I agree with you. There is something to be said in favor of a uniform protocol on arbitrability of disputes in international arbitration so that it does not undermine their enforceability eventually in convention countries. And I think this pretty much gels with my earlier suggestion that there is something to be said in favor of divorcing the philosophical foundations of domestic arbitration in India from the jurisprudential basis of international arbitration. It is possible in a country like ours to ensure that we meet the international benchmark on all protocols, on arbitrability, on whatever is expected in party autonomy, and yet we follow, at a domestic level, we follow what we think is suited to the reality of our civil society.
Thank you so much. Are there any other questions from the audience? Fantastic. We have a gentleman at the back, please. Can you please hand over the mic to him?
Not a question really, but a statement, and I would like the speaker's reaction. We are discussing party autonomy, but in a significant number of cases, it is really illusory. There's a dominant party who can dominate the commercial terms and the contents of the arbitration agreement. The same parties, if they went to court, would be at a far more level playing field. Therefore, provisions like Section 12(5), which require an agreement post-contract being awarded, post-dispute, are more reflective of true party autonomy. Those encourage greater confidence in the arbitration process. Your reaction to that?
Yeah, and you are right. I entirely agree with you, and that is what I said when we were thinking of the contrast in the two approaches of development. On the one hand, there are very I would say bold judgments of the Indian Supreme Court where party autonomy is given to the extent of choosing not only the foreign jurisdiction for curial, but even substantive law also of other countries. And two Indian parties who contracted in India, dispute arises, they say we'll not only go to Singapore, we'll even choose Singapore law, and even that is upheld by our Indian Supreme Court. That is one aspect. On the other hand is 12(5), where it is curtailed party autonomy. And what you say is correct, and I also said that here we are, the philosophy behind Section 12(5) is the integrity of the arbitration. And we don't want, even if there is a little suspicion about the impartiality of an arbitrator, so that person should not be there as arbitrator. And that is why Schedule 7 talks of those grounds on which the person would be ineligible to act as an arbitrator. So therefore, on that, both Gaurav and Ms. Gupta have mentioned about how the law is developing. Some high courts in India have taken contradictory approach, particularly post-award this challenge to the impartiality of an arbitration and where we go from there, of course, and whether the issues of waiver, etc., would apply, under what circumstances, whether the disclosure was given at all or not, and if there was a waiver, whether it was in writing or in orally something was said. All those issues, and these would be different intricacies or the nuances of the disputes which may, and we hope that in the course of time this all would be corrected and there would be a uniform policy, particularly when the matter reaches the Supreme Court, and so therefore some judgment would come which would be determinative of this issue. But you are right that 12(5) is important, particularly when the two parties may not be at the same level. And I think I started in the first instance in that as a Supreme Court judge, when the judgment was given by me that the panel of arbitrators suggested by, this was of Metro Rail, that you appoint only from there. So we said, sorry, you are, you cannot, one party cannot bind the other party to choose the arbitrator only from that panel provided, and it should be left to them. And in Perkins, as was told to you by Gaurav, that the court went ahead and expanded this principle. So therefore, law is in a developing stage, and it always remains in developing stage. And good thing is, which is happening in India, is that good international practices are now being followed. And Schedule 7 is an example to that, which is followed legislatively.
So taking, yes.
Yeah. Lynn, I wanted to add to what Justice Sikri just said. I agree with you. In fact, when I look at Section 12(5), while Section 12(5) per se impacts the autonomy of parties who have entered into a contract earlier giving a unilateral right of appointment or appointment of an employee who's hit by the disqualification. The proviso, in fact, is a provision that enables parties to waive that requirement in a particular manner. So there's a very interesting balancing exercise in 12.5, taking away party autonomy to some extent with respect to certain contracts that for policy perspective, from the policy perspective are found to be offensive, and yet giving parties the autonomy to reassess their position and then reiterate that in a written form. And it is because of the proviso and the manner in which the balancing exercise is undertaken, I in fact believe that where courts have held that it is not possible to waive the prohibition of 12.5 by mere conduct, that you must necessarily follow the strict manner in which it can be waived, which is by entering into a contract. And there is no other way that this disqualification can be waived. I personally believe that that perhaps is the correct view, and it is a very good balancing exercise between some curtailment of party autonomy coupled with the ability to reaffirm what parties expect to achieve. Thank you, sir.
Justice Sikri, if you may allow, there's
Yes.
just one question that the audience
Okay.
has, and we'll take the last question and probably end. Yes, gentleman there, please. Right behind you, Mark.
Thank you. My name is Christian Roth. I'm an attorney in Paris, France. I would like just to comment a little bit on the emergence of commercial courts and give the French experience. I'm a little bit astonished to hear that you have an emergence of commercial courts. In the French system, commercial courts have always existed since the mid of the 19th century with the emergence of industry. And we have, in the legal system in France, we have the institutional judiciary, tribunaux civils, and we have the commercial courts, tribunaux de commerce. To the difference of the judiciary, which is composed by state judges, the tribunaux de commerce are composed by elected judges who are elected within the frame of the chambers of commerce. And these judges are elected for a tenure of 4 years, renewable 3 times. That's a total of 12 years. Their work consists, they are not paid for the job of a judge. They receive just a per diem. But to give you an example, the Paris Tribunal de Commerce is composed of 120 judges divided in 18 different chambers. One of them is, as you mentioned, Mr. Moriarty, the international chamber of the Tribunal de Commerce. I must say that it was not created especially because of the Brexit, but it evolved into an international chamber specialized for dealing for international disputes, because there is evidently in Paris a large commercial activity that is supported also by international law firms present in Paris. Therefore, there was a demand on the side of the practitioners to be able to bring a case in a foreign language other than French. And it is indeed now possible to have a dispute between parties in front of a judge or panel of judges in English language, and with providing documents in English language. The only problem that arose was that, according to law, the sentence had to be written in French. And why in French? Because for the possibility to be brought into appeal, the Court of Appeal, which is the second instance after the first instance of the Tribunal de Commerce, being a state court. Therefore, legislation has been passed recently, introducing with the Court of Appeal of Paris only, an international chamber of the Paris Court, of the Court of Appeal, where the cases coming from the Tribunal de Commerce, from the Commercial Court of Paris, and going into appeal will be heard by a specialized section of the Court of Appeal of Paris. But just to give you the feeling that because of this intricate organization of commercial courts, there are 120 commercial courts in all of France. In every circumscription, in every court circumscription of France, there is a commercial court. This system has, of course, given a lot of assurance to parties not to go immediately into arbitration, because the commercial courts, being composed by commercial people, by business people, the parties feel confident to be in front of their peers. The only advantage for going into arbitration in the view of the parties in France is that it is secret. There is secrecy about the proceedings. The disadvantage is that it might be costly. And therefore, there is a larger confidence in going to these institutionalized commercial courts rather to go to litigation. But for purposes of international litigation, it is true that parties may be not so confident in the fact that in front of a French judge, commercial judge, the matter will be heard according to French law, if French law is the law of the contract, and therefore international parties will be more prone to go to...
We'll request you, I mean, you have said and explained it beautifully, but we are
I wanted
run the time.
Yes.
Yeah, so thank you very much for
it was just
about
sharing the
you.
experience.
Yeah, thank you very much.
Thank you.
And let me thank all the three panelists. I think we have one saying in Hindi, Gagar mein sagar, that is putting entire ocean into a bucket. This party autonomy is such a topic which can be discussed for hours, but in this 1 hour 30 minutes, all three of you, the manner in which it is explained, and I think every aspect and all nuances of the topic, the way these are discussed. So I thank all the three panelists, and I thank all the every person sitting in the audience, and I hope that you would have found that it was quite useful. At least I say that, speaking for myself, I have learned a lot. Thank you.
Thank you so much, Justice Sikri. Thank you to our panelists. What a fitting session to be our inaugural session on party autonomy. May I please request the delegates that to please proceed for coffee to the 7th floor lounge. There's hall number 10. I'm sure there are lots of questions amongst the audience, so you can catch our speakers and our panelists post the session as well. And thank you so much to our panel for joining us.